Good morning, everyone. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our webinar today, Integrating Your Business and Estate Plans. So how this will work today, if you're new to our webinars, and if you are, welcome. We're glad you're here. You are on mute, however. If you have questions, please do post them throughout the presentation in the questions panel on the right-hand portion of your screen, and I, as the moderator, will send them to Chuck throughout the presentation. You also received the slides by email this morning from me for your convenience to take notes on them if you wish. Everyone will also receive a brief post-webinar feedback email right after the presentation. And we do ask that you please take just a couple minutes to fill out this valuable feedback to offer us your thoughts about the presentation. Also, for CFPs, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. So if I do not have it already, for my records and per the requirements of the CFP Board of Standards, please email me your board ID number. And specifically for CPAs only, I also need the last 4 digits of your social security number as soon as possible. So I'd like to give a warm welcome to our presenter today, Mr. Chuck Borek. Chuck is Special Counsel to Elville and Associates and founder of the Borek Group, LLC. He is a business and tax attorney with almost 30 years of experience representing individuals, small businesses, and nonprofits. Chuck earned his joint JD and MBA summa cum laude from the University of Baltimore, where he was the editor-in-chief of the Law Review and the recipient of the 1993 Law Faculty Award. He has taught law students as a visiting professor and adjunct professor of law at American University and the University of Baltimore, and has lectured at Dickinson Law School at Penn State University. Chuck has written for Thomson Reuters, Bloomberg BNA, and the American Institute of Certified Public Accountants. His book on contract drafting is used by lawyers throughout Maryland and has been cited by the Maryland courts. Additionally, Chuck presents seminars to CPAs and lawyers around the country through his company, the Borek Group, LLC, including presentations to Big Four accounting firms and Fortune 500 companies. He also lives with his wife, the youngest of his 4 children, and 2 dogs in Howard County, and is currently pursuing graduate work in theology and literature at Wesley Theological Seminary in Washington, D.C. So everyone, you're in very good hands with Chuck today. And Chuck, we appreciate you being here today to offer your expertise. So I will turn it over to you. Thank you.
All right, thank you, Jeff, and good morning to everyone. Today we're going to talk about integrating your estate plan and your business plan. Very commonly, people do those 2 things separately, sometimes even using separate lawyers, separate law firms, separate accountants even. But your business planning and your estate planning really do need to be integrated for a lot of reasons. One of them is that, your business assets sometimes are the most valuable thing in your estate. And so without planning for, properly planning for your business interests in your estate plan, there's all sorts of things that can go haywire and vice versa. In your estate planning, it's important to take into account all of your important assets, and one of those undoubtedly is your business interest. So today we're going to talk about planning that sort of crosses over between estate planning and business planning, and how we should think about the 2 as an integrated whole. All right. To do that, I've separated my presentation here into 9 specific things that I see people doing all the time that cause problems in their estate and business planning. So we're going to look at the 9 estate and business planning mistakes that I often see. And with respect to each of those mistakes, we'll talk about what the opportunities are to correct them and to make sure that you utilize the available mechanisms to properly plan for your estate and business needs. So with that, we'll get started. Mistake number 1 is forgetting to name successor agents, proxies, executors, and trustees in your estate planning documents. Your agents that you name in these documents, not only should they be coordinated, but certainly the agents themselves and who specifically you're naming is very important. You want to have successor agents as well. We don't generally advise having just one agent, because if that agent is unable or unwilling to perform then in most cases, what will happen is a court will appoint an agent, perhaps a corporate agent, not necessarily an agent that you would choose, not necessarily an agent that's going to act in the way in which you would like them to act. So it's really important to name successor agents that take effect with respect to the documents that take effect during life. So for example, your power of attorney, you want to have a successor agent in your power of attorney. Now, that successor agent can be a springing power, or we can simply do another a separate power of attorney. Springing powers are powers of attorney where the agent, the successor agent, becomes the agent if you become incapacitated, as opposed to automatically upon signing the document. Springing powers have some problems in and of themselves. One of the difficulties with powers of attorney is, although the law and the document itself strongly encourage people to accept a power of attorney, sometimes people are hesitant to do so. And so we'd like to try to ameliorate that as much as possible. With a springing power of attorney, that might exacerbate the problem sometimes, because now not only do you have to convince the third party to accept the power of attorney, but you also have to convince them that the event that triggers the power of attorney has taken place, for example, your disability. So there are some complexities there that you want to think through with your attorney and determine what exactly is going to suit your needs, specifically with respect to the financial power of attorney. Now, we generally don't have that issue with the healthcare proxy or the healthcare power of attorney, or what we call the advance directive. That's really important to have a successor there, because, again, you're generally going to name the person that's closest to you as your primary agent, right? This is the person that will make healthcare decisions if you're unable to do so. But if that person is not available, then we want to have at least one successor, and often two successors, just to be safe. And the same is true with lifetime trusts. If you have a revocable living trust, you're the original trustee, but one of the benefits of a revocable living trust is that should you become incapacitated, somebody can step into your shoes automatically without having to go through any sort of court proceeding, and manage your assets and control all of your resources for your benefit. That requires a successor trustee. And so you want to make sure that you have a successor trustee and that you've named a successor trustee that's appropriate. And again, having two or even three successor trustees might be appropriate under the circumstances. Again, everybody's circumstances are different, and so you have to discuss your specific situation with your attorney to determine what the best procedure is for you. Now, of course, there's other documents that take effect at death, such as your last will and testament, right, your will, or any trusts that are contained in your will, testamentary trusts. Those trusts don't come into existence until you die. Well, it's vitally important that you have appropriate successor agents in both of those cases, because, of course, once you're dead, you can't change those agents. So you have to think about that while you're constructing those documents. The good news is all of this stuff can be changed while you're alive. So, you know, as you go through planning, even if you have planning documents in place, or if circumstances change, you can always modify your successors, right? In terms of a financial power of attorney, as I said, there's lots of different issues that you want to consider. Remember that the financial power of attorney can do anything you can do financially. I mean, they can write checks, they can sue people on your behalf, they are the defendant, they can defend lawsuits on your behalf, they can take money out of your account, they can put money into your account. So obviously you want to have somebody that you trust. Now, before, you know, that sounds frightening to some people, right? To give a power to somebody else that can do all those things. But remember, anybody you give that power to, any agent you name, becomes your fiduciary. Right, so they are legally obligated to act in your interest. Sometimes my clients will say to me, well, gee, if I sign a power of attorney saying that my spouse or whoever else I'm naming as my power holder has the ability to do all this stuff, what prevents them from going down to the bank and just taking all my money? Well, what prevents them from doing that, of course, is laws against fraud and other criminal laws, right? That would be a crime to do that. So the power of attorney doesn't give your agent carte blanche to do whatever they want. It only gives your agent the power to do the things with your assets in their capacity as a fiduciary on your behalf, right? And they would be liable civilly and potentially even criminally if they didn't do that. So there's really some good protections there. So you really needn't fear having a financial agent in your power of attorney. Now, if you want to have multiple agents raise some difficulty sometimes. What you want to do is you want to think through how you want those multiple agents to work. The default rule in the law, if you have multiple agents, is that everybody has to agree in order to do anything, right? And that's generally not a good situation. Typically, what that results in is paralysis, right? If you have 3 agents and they all have to agree on anything in order to do it, it's common, as you probably understand just through living your life. Anytime you need 2 or more people to agree on something, there's always a strong possibility that that agreement won't take place. And if the agreement doesn't take place, then nothing can happen. If you have one person, if the agents don't get along or have some sort of dispute, they may intentionally not agree, and then again you have paralysis. So there are ways around that. We can draft around that. We can talk about in the document those issues where they have to act jointly and those issues where they can act separately. And again, we can think that through based on your particular circumstances and your particular need. As with all the issues we're talking about today, there is no one-size-fits-all solution. Your specific circumstances, your specific desires need to be taken into account. Now, if the primary agent, of course, becomes incapacitated, you need to have a successor agent. But also, the primary agent may simply choose not to act. You can never force somebody to act as your agent in any of these documents. They may simply change their mind and decide that it's not a responsibility that they want to take on. So again, those are 2 reasons that you really that's really make it really important to have successor agents. They may choose not to act, or they may be unable to act. As I said, in a healthcare proxy, even more important, because this is the person that will make medical decisions on your behalf. This is the person that will decide whether or not to consent to a procedure if you're incapacitated and cannot consent. By the way, under the law, you're always the person, the patient is always the person whose consent is needed. A healthcare power of attorney only comes into effect if you cannot make a decision, if you're incapacitated, if you're unconscious, or you're in a coma, and the physician or the healthcare professional cannot get consent from you. That's the only time it kicks in. So it isn't as if you're cognizant, an agent can make a decision contrary to your wishes. Now, this healthcare proxy or advance directive, this is what we used to refer to as a living will. Legally, these documents are much better than living wills. Back in the old days, a living will was just a statement to the world, right? Where you would sign a document that says, if certain conditions befall me, this is what I want to have happen, whether you want to be put on life support or taken off life support, et cetera. And it was just a statement to the world. And so healthcare providers were understandably reluctant to abide by those in many cases, because they didn't know if you had changed your mind, or if if you had even revoked that particular document. The whole point is you're incapacitated at the time, so they can't ask you. We've overcome that in every state now with legislation that allows for these healthcare proxies or healthcare powers of attorney or advance directives. And they all mean the same thing. In each case, what we do is we name somebody else as an agent to make those decisions. And because of that, the healthcare provider gets to deal with a live human being, right? It's the agent making the decision, so they don't have to rely on just a document. Now, in that document, typically, we'll specify what it is you want to have happen. And sometimes, we're very specific about those things, but the agent always has the power to decide. So what's most important is that your agent understands your wishes. Healthcare decisions are very tied to the circumstances, right? People sometimes make choices that they later decide to change. Well, that's okay, because the law requires your healthcare proxy to make whatever decision, to implement whatever decision you want. So only if they know that you've changed your mind about a certain decision that's in your written healthcare proxy are they permitted to give a different instruction. Right. Successor agents and wills and trusts, right? The agent in a will or a trust basically are individuals who will administer the will or the trust, right? We call them a personal representative in the case of a will. You can have a specifically named successor trustees, or you can specify how the successor trustees will be named, a criteria for naming them. You have to have, well, you don't have to, but you really should have at least one, right? It would be highly recommended that you always have at least one successor agent, and again, 2 or even 3 might be appropriate. The successor agent is important to have your document fully implemented. There are powers in the document that may not be able to be utilized if you don't have a properly named successor agent. Again, especially in the case of a will, if you don't properly name a successor agent and the agent you've named in your will is unavailable or unwilling to proceed, then the court has to appoint someone. There will always be a personal representative of your estate. It'll either be someone of your choosing or it'll be someone the court appoints. And again, this is such a personal matter, handling your assets after your death. You certainly want to be the one that makes that choice rather than leaving it up to the court. So naming those successor agents, vitally important in wills and trusts. All right, let's move on to mistake number 2, neglecting to properly structure a business venture to protect personal assets from business creditors. Well, one of the problems with owning a business is business are plaintiff generators, right? No matter what kind of business you're in, there's always all sorts of potential claims that could come up. Now, hopefully you run a business and maybe run it for many, many years and never have any claims and nobody ever sues you. And hopefully that's the case. And then you don't have to worry about these things. The problem is you don't know if you're going to be the lucky one for which that's the case, or if in fact claims are going to arise during the course of your business. That can be anything from a claim based on some good or service you provided to your client to a slip and fall on your premises. There are product liability claims. There are claims with respect to employees, right? Your employee, if they feel they've been terminated improperly, for example, could sue their employer. So the question in all these cases is, who is the employer? Who is the business? If it's a sole proprietorship, the business is just you, which means all of your assets are at risk. Your house, your bank accounts, your car, everything you own is potentially at risk. Now, the good news is we have lots of ways around that, and they're generally fairly easy to implement. But again, they have to be properly integrated into both your estate and business plan. So there's sole proprietorships, which I just talked about, which generally you want to avoid. There's partnerships, there's corporations, and there's the limited liability company. So I want to talk about each one of those things briefly. First, with the sole proprietorship. Again, as I said, sole proprietorships give you no protection from risks. Basically, you and the business are one and the same thing. If anybody, whether it's a customer or a creditor or an employee or other agent of your business, wants to sue based on some business transaction or something that happened in the context of the business, they are suing you personally. And again, all of your assets are at risk for that. The only thing that you can be protected by in that case is insurance. Now, insurance, should be part of the asset protection planning. You may, in fact, want to have insurance for different types of risks that you might be subject to. But there's no insurance, or at least no practical insurance that's affordable that's going to cover all possible business risks. So sole proprietorship is always going to leave you open to some risks that generally you want to avoid. And as I said, the good news is it's relatively easy to avoid those risks. We have lots of different options. All right, well, let's talk about some of those options. First of all, an option which in and of itself doesn't help is a partnership. I say in and of itself because there are alternative forms of partnership, right? So we're talking about three different kinds of partnerships. A general partnership, a limited partnership, then I'll talk about something called a limited liability partnership. Now, in a general partnership, which, by the way, is formed based on the facts. And what I mean by that is in order to form a partnership, you don't have to sign anything. You don't have to file anything with the state. There are no formalities required. What the law says is if you have two or more persons who are acting as co-owners of a business for profit, you've got a partnership, right? Unless you've got something else, unless you've formed an LLC or a corporation, you've got a partnership, whether you know it or not. The problem with that is under the general rules of law, all of the partners are jointly and severally liable for all of the partnership debts, which means that if one of your partners does something that incurs a debt on behalf of the partnership, you're liable for it in a general partnership. So general partnerships are, in a sense, from a liability standpoint, even worse than sole proprietorships, right? With a sole proprietorship, you're going to be liable for anything you oversee and anything you do. With a partnership, a general partnership, you're liable for anything you do, and you're also liable for things that are done by your partners, right? So you've expanded your liability. Now, the good news is, again, there are easy ways to avoid this. One simple way to avoid it, or to limit it at least, limit the risk, is to form a limited partnership. Right? If you form a limited partnership, you still have to have one general partner, and that one general partner is liable for all the debts of the partnership. But all the other partners can be limited partners, and the limited partners, as long as they're not involved in the operations of the business, they're protected from liability. Now that works fine if you have one person, for example, who's going to run the business and a bunch of passive investors, right? People who are just going to invest in the business, be owners, but not actually participate in the business. If they're going to participate in the business, their status as limited partners won't be respected. Now, what about that one general partner that's running the business? Well, we can take advantage of other forms of liability protection for them, right? We talked about insurance, but we can also utilize the corporate law or the LLC law, right? That general partner can actually be a corporation or it can be an LLC. So we can handle that liability protection separately. Right? But in that event, we only have to deal with the liability of the person running the business. We can have investors come in without any liability. Now, it's also something else called a limited liability partnership. A limited liability partnership is not really a different kind of entity. It's really just a partnership, but state law now allows you to elect to be a limited liability partnership. And if you do that, that means that your partners are not jointly and severally liable for partnership debts. So you might say to me, well, if we're going to have a partnership, why wouldn't we elect to be a limited liability partnership? And the answer is there is no good reason not to elect to be a limited liability partnership, right? If you're going to organize your business in partnership form, you want to make that election because that protects everybody from liability. The only reason, generally speaking, in Maryland, that people do not elect to be limited liability partnerships is because they're ill-advised. They either don't realize that that possibility exists, or they simply haven't been advised to do that. There are some states where there are some special circumstances where it may compel you not to be a limited liability partnership, but those circumstances generally don't exist in Maryland. So there's really no reason to have a general partnership in Maryland. You should at the very least be a limited partnership, or in most circumstances, it's actually easier just to be a limited liability partnership to protect the partners from the debts and liabilities of the business. Now, a corporation does that too, right? The reason a corporation does that is because a corporation is considered a separate person under the law, right? The corporation and you are even if you're the sole shareholder, the corporation and you are deemed to be separate persons. The corporation acts on its own. When you do business with a corporation, you're doing business with that corporation. Now, the corporation, because it's not an actual person, needs agents, right? And so the officers and directors of the corporation and its employees are the agents of the corporation. But when you buy, something from Walmart, you're not buying it from Sam Walton or Sam Walton's descendants or any of the shareholders or officers of Walmart. When you buy something from Walmart, you're doing business with a corporation known as Walmart. And so if something goes wrong, the other party to that transaction is Walmart. You sue Walmart. So that's why you have liability protection in a corporation. There are exceptions. There's something known as piercing the corporate veil. When a court might say that, well, you formed a corporation on paper, but you really haven't treated it as a corporation. And so therefore, we're going to do what the law refers to as piercing the corporate veil. And make the shareholders, the owners, liable as if it were a partnership. That's again with proper drafting of the documents and proper operation of the corporation, you can avoid that. You simply have to, make sure that you're paying attention and you're doing and you're operating the business the way your lawyer has advised you to. There are other ways, I suppose, in a corporation where you can have personal liability, right? You can personally guarantee a loan, for example. Well, if you personally guarantee a loan, the fact that the business is incorporated really doesn't have any effect. Also, you might be liable for a personal tort claim. This is one of the things that people don't always understand. You're always liable for your own negligence, right? So if you, as a human being, commit some negligence, right? And remember, negligence is an accident, right? It's an unintentional harm. But if you act negligently, whether you're working for a corporation or you own the corporation or you're working for an LLC or an LLP or anything else, it doesn't matter. The tortfeasor, the person who commits the tort or commits the negligence, is always personally liable. Now, the issue in those cases generally is, will the employer, whether that's a corporation or an LLC or something else, will that corporation or other entity also be liable, right? So if the UPS driver negligently smashes into your car and totals it, well, yeah, the UPS driver is negligent and therefore is personally liable. However, UPS, the company, probably has much more in the way of resources and insurance than the UPS driver. So your claim from a legal perspective, you're going to want to assert against UPS. Now, there's a whole set of rules about whether or not UPS would be liable. But that's why we look for what we call vicarious liability of employers, not because the person who committed the tort is not liable, but typically the business has more resources and we'd rather sue them and collect from them rather than from the individual. So my point is that you're not protected from your own personal negligence, but you are protected from things that others negligently do. So, for example, your employees and your agents and the other owners of the business, you're not liable for anything that they do. That's the type of protection you have if you're a corporation. Now, limited liability company is probably the most commonly used form of organization for small businesses specifically, but even for substantial sized businesses. And that's because the LLC is very flexible. It's flexible from a tax standpoint, and it's flexible from an operations standpoint. It's not a corporation, but it has the same liability protection as a corporation, right? And so the assets owned by the LLC are no longer your assets. They're owned by the LLC. The LLC, in this sense, is treated as a separate person, just like a corporation. And your personal liability, not only are the assets of the LLC not subject to your personal liability, your personal assets are not subject to the liability of the LLC. So transferring assets to an LLC can provide liability protection. Now, whenever we transfer assets, by the way, and I just want to make this general comment as we're talking about this, you have to be concerned about and aware of something called fraudulent conveyances, right? A fraudulent conveyance is when you owe somebody money and you transfer assets for less than full consideration, less than their fair market value, as in a gift or something like that. You transfer those assets so as to avoid having to pay the person you owe money to. That's a fraudulent conveyance. And fraudulent conveyances will be set aside, all right? So when we're doing asset protection planning, it's really important that we do it before you have creditor problems. All right. It's not one of the mistakes that I've listed here in my 9 mistakes, but it's really maybe the biggest mistake people make with respect to asset protection plan. They don't think about it until they have creditor issues, and then they say, I want to protect my assets. Well, once there's a potential claim against you, it's really too late in many circumstances to protect your assets, because any transfer of your assets is going to be avoided in the law. It's going to be ignored, in other words. So it's really important that you think through these things ahead of time and do the planning in conjunction with your estate planning. As you're speaking to your attorney about these things. Let's move on to mistake number 3. For businesses owned by more than one individual, neglecting to have an owner's agreement and a binding buy-sell arrangement. Now, the buy-sell arrangement is typically incorporated into the owner's agreement. The owner's agreement, what we call the owner's agreement, is simply based on the type of entity it is, right? So if it's a partnership, we call it a partnership agreement. If it's a corporation, we call it a shareholders agreement. If it's an LLC, we call it an operating agreement. But they all perform the same function. And not only do they deal with issues such as management and distributions, and in the case of a partnership or an LLC, they'll also deal specifically with tax issues, very important tax issues. So the ownership agreement is really important if you're going to be taxed as a partnership. But also they may and should contain this buy-sell agreement. Now, the buy-sell agreement or the buy-sell arrangement is simply an arrangement that discusses how a business interest will be sold, how your ownership interest will be sold or transferred upon certain triggering events. Those triggering events include things like death, right? Certainly, that's one of the things we want to think about in terms of our estate planning, but also disability. This is something that people often don't pay as much attention to as they should. Statistically, you are much more likely to become prematurely disabled than you are to become prematurely dead. That's just a fact. So people spend a lot of time planning for their death with insurance and all sorts of other mechanisms that we can put in place to protect your family in the case of your premature death. But frequently people don't think about their premature disability. And a premature disability, right, a disability when you're still earning money and working, is devastating for the family, because it's actually literally worse than death from an economic standpoint, right? Because with death, of course, you remove your ability to earn money for your family, but with a disability, not only do you do that, but you also still have to be fed and clothed, and the resources of the family have to be used for that. So disability can actually be a more devastating situation than a premature death from an economic standpoint, right? Also, what if somebody wants to buy your interest? Do the other owners, do they get a chance to buy it instead? Typically in a smaller business, a closely held business, we're in business together because we know each other, right? And generally speaking, you probably don't want to be in a situation where suddenly a stranger is thrust upon you as a partner, and suddenly you have to do business with somebody you don't know, maybe somebody you don't even like, right? And so very commonly, one of the triggering events in a buy-sell will be when somebody wants to transfer their ownership interest. Termination of employment, if you just want to quit, if you just don't want to work with the other owners anymore, right? That might be a triggering event. Divorce, right? Because in divorce, assets might get transferred to the spouse, and again, just for the same reason, you may not want to be an owner with one of your co-owners' ex-spouses, right? And bankruptcy, and actually bankruptcy is an important triggering event, because in a bankruptcy, by law, by operation of law, all of your assets get transferred to the trustee in bankruptcy. So again, that's a person you don't know, and generally speaking, you don't want to be in business with people you don't know, and so typically bankruptcy is also a triggering event. Now, with respect to buy-sell agreements, what we do is we structure the sale. We say under what circumstances the interest will be sold, and we even talk about what price will be paid and how the price will be paid. Will it be paid all at once? Will it be paid in an installment note? If it's going to be paid in an installment note, how long of an installment payment will we use? a buy-sell agreement can have all sorts of different facets, again, based on your facts and circumstances. Now, with a buy-sell agreement, remember, we have multiple owners, right? So typically they have to be negotiated. The issue with a buy-sell agreement is that everybody is generally motivated to have a fair and reasonable agreement, because we generally don't know who's going to be on what end of the bargain, right? We don't know if you're the one that's going to want to sell the business to somebody else, or if you're the one that's going to want to leave, or if you're the one that's going to become disabled, or if you'll be one of the owners when one of the other owners, one of your partners, has one of those triggering events. So in other words, you don't know if you're going to be the buyer or the seller, and so as a result, there's a motivation for everybody to come up with an agreement that would be fair, regardless of which side of the transaction you're on. One of the things from a tax standpoint and from an estate planning standpoint that we use buy-sell agreements for is to establish value. One of the problems in your estate, if you have a small business interest, is establishing value can be very difficult, right? We can have valuation analysts, but depending on the nature of your business, that might be a very expensive process, and it's certainly subjective, right? Two different valuation analysts can come up with two different values. In a buy-sell agreement, if we do it properly, we can establish what the value is, and we can establish it in such a way that the IRS will respect that value. So that's a very important feature, a tax feature of a buy-sell agreement. Buy-sell agreements generally come in one of two forms, either cross-purchase agreements or redemption agreements. Now, we can also mix those two forms. A cross-purchase agreement simply means that the other owners buy out the leaving owner, whether that owner is leaving because of death or disability or whatever triggering event. The other owners buy that out. With a redemption agreement, the entity itself, the corporation or the LLC or the partnership, the entity itself redeems the interest. All right. Now, there are different tax ramifications of those two things, and there are also practical ramifications of those things, and I'll talk about that in a minute. We also can have a hybrid agreement. Now, the hybrid agreement, as the name implies, it's sort of part cross-purchase and part redemption. Typically, the way it'll be set up is the entity gets an opportunity to purchase the interest first, and if the entity chooses not to, then the owners have an obligation to buy it. Now, again, there are very specific tax ramifications depending on the facts and circumstances of that arrangement, and so you want to make sure that you've chosen an arrangement with the tax ramifications in mind. There are also estate planning ramifications, right? If you have the obligation to purchase an asset, that's going to diminish the assets that are otherwise in your estate. Whereas if the entity is buying the assets, it doesn't affect your estate. So there's all sorts of factors that need to be considered and worked through to determine what the best approach to a buy-sell agreement is. The key thing, as I said, one of the key things is valuation. And there's lots of different ways we can place a value on the interest in a buy-sell arrangement. Generally, you don't want to have a fixed value, right? Because the value of the business is going to change over time. So again, remember, you don't know if you're going to be on the buying side or the selling side. And so you want to make sure that you have an arrangement that's going to be fair to you either way. And just having a fixed dollar amount is generally not the optimum way to do that. Now, one of the ways we sometimes address that is we say, all right, well, we'll set it every year, right? We'll meet every year, have an annual meeting, and decide what the number is for that year. And that way we can update it at least once a year, and it should be fine. The problem is people tend not to do that, right? In my experience, when we set that up, you meet the first year, you establish a value, and then people just forget about it, and you never meet again. And then several years later, there's a triggering event, and you're stuck with that value that you agreed upon, 5 or 6 years earlier. So that's a solution I don't particularly like in my practice. I usually recommend against that. You can use the book value, right? Book value is easy to ascertain. It's just the accounting value of your business. That, again, is generally not a very good solution because, generally speaking, book value doesn't really reflect real value of a business. And again, that'll vary depending on the type of business it is. But book value is generally not a favorable way to determine value. But there's lots of other ways. There's capitalizations of earnings, for example. You can use a value similar to the way a third-party valuation expert would determine a value. In other words, you can come up with some formula and say, all right, the value of the company at any given time is X amount times the the earnings over the last 3 years or whatever. Sometimes we do actually consult with a valuation analyst at the outset to come up with that formula. The good thing is once you come up with the formula, you never have to change it. It's just a formula that can be applied no matter when the triggering event occurs. Now, you don't always need to have a valuation expert to do that. Sometimes the owners of the business are really the best ones to come up with a formula. But once you have that formula in place, it makes things a lot easier. You don't have to revisit it every year. You don't have to worry about if the formula is properly conceived. You don't have to worry about it not reflecting the actual value of the business. So those are the methodologies we generally use. Now, the next question becomes, how are you going to have the money? Where's the money coming from to pay for this? Suppose we have a cross-purchase agreement, which is very common. How do I know that everybody's going to have the money to actually fulfill their obligation to buy my interest upon my death or my disability? Well, very frequently we fund that obligation with insurance, right? Particularly for the triggering event of death, we can fund it with life insurance. Now, there are problems there too, right? That's not a perfect solution because, first of all, not every member may be insurable. You have to make sure that the insurance premiums are paid. So you have to decide, well, is everybody going to be responsible for their own premiums? Is the company going to pay the premium so that we make sure that all the insurance policies are kept up to date? If you have lots of owners, it may just not be practical to have, because every owner has to have insurance on every other owner, right? So if you have 10 owners, each owner has to have 9 insurance policies, right? That's a lot of insurance. Now there are ways around that. Sometimes, we can set up a separate entity to own the insurance and have sufficient insurance to cover everybody. Then you just have one entity in that case that has to purchase insurance. And there are other solutions as well. But those are problems that have to be addressed, have to be thought through with respect to your business. And if not, upon your death, even though you might have done tremendous estate planning, that could really screw it up if you don't have a sufficient and adequate buy-sell agreement. Right, mistake number 4, having inadequate beneficiary designations for retirement plans and IRAs that don't coordinate with the rest of your estate plan. Remember that any accounts that have a designated beneficiary will transfer to those designated beneficiaries by operation of law. In other words, your will or your testamentary instrument, if it's a revocable living trust, for example, doesn't affect that, right? If you have a designated beneficiary, the asset goes to that beneficiary by operation of law upon your death. So those designated beneficiaries need to be integrated into your estate plan. When I do estate planning, I typically ask my clients to actually obtain the documents or information from the custodian as to who the designated beneficiary is. A lot of times what happens is people designate beneficiaries on accounts sometimes years before they do estate planning or years before they update their estate planning. And sometimes they've simply forgotten who they named as beneficiaries. And what's worse is they think they know who they named as beneficiaries, but their memory may fail them, right? Especially if circumstances have changed in your life. So you may have changed beneficiaries and forgotten about it, or named a beneficiary that you didn't realize that you had named. So it's always a good idea to actually review physically who those designated beneficiaries are. And what I mean by that is, contact the custodian to make sure you know precisely who the designated beneficiaries are. So all of those designations need to be reviewed and incorporated into your estate plan. You also want to think about beneficiary options, right? In some cases, you may want to name a trust as a designated beneficiary. In other cases, that may not be a good option. Generally speaking, you don't want to name your estate, right? You certainly don't want to name designated beneficiaries that contradict the other things you're trying to do in your estate plan, right? The fact of the matter is your designated beneficiaries are part of your estate plan, whether you like it or not, or whether you know it or not, right? So yeah, you have to understand who those designated beneficiaries are and make sure they are the optimum designated beneficiaries within the entirety of your estate plan. As I said, naming your estate as a beneficiary is generally not the best idea. First of all, with retirement assets, that means that the money has to come out much more quickly, generally, than if you name a person as the beneficiary. There's all sorts of estate planning nightmares that can be a consequence of naming your estate as a designated beneficiary. And by the way, if you don't name a designated beneficiary, right, if you don't properly name one, your estate becomes the designated beneficiary automatically. And again, that can be troublesome. So another good reason why you want to make sure you review those designated beneficiary designations and make sure that they are successfully integrated into your estate plan. Remember, you have to do that while you're alive, right? Can't change those designated beneficiaries after you're dead. And that's unfortunately sometimes the circumstance we confront, where a client dies and we're administering their estate. We find that they have sometimes significant assets in these designated beneficiary accounts, which don't have the optimum designated beneficiary. So it's important to make sure that you've planned for that, because once you die, you can't address that situation. Mistake number 5, ignoring formalities, such as board and shareholder meetings with minutes to ensure the entity is respected for all purposes. This is particularly important with respect to corporations, all right? The good thing about LLCs is there aren't a lot of formalities, right? So there's not a lot of hoops you have to jump through. Corporate law, and in some cases, it's a good idea to be a corporation. Again, all the facts and circumstances are different. So it's impossible to say that an LLC is always better than a corporation or vice versa, all right? Again, you got to make sure that you are properly utilizing or properly planning in the context of the specific facts and circumstances. But if you have a corporation, one of the drawbacks is there are a lot of formalities required. You have to have an annual meeting of shareholders. You have to have directors and shareholders, unless you have something called a statutory closed corporation, which again is an option that you should consider in consultation with your attorney. But if you have a corporation, you need to have those meetings. You need to have minutes. You need to treat the corporation like it's a corporation, right? This brings up that issue that I'd mentioned earlier, this idea of piercing the corporate veil, right? What it boils down to is this. The courts say that if you don't treat the corporation like a corporation, then there's no reason for us to treat it like a corporation either. And if we ignore the corporation, then essentially what you have is a partnership, or perhaps a sole proprietorship if there's only one owner. And that means that that sole proprietor or those partners, those owners, become personally liable for the debts of the corporation, right? Something that you clearly want to avoid. Now, what sorts of things do you need to avoid specifically? Well, first of all, you want to make sure that you actually hold the required meetings that you have to have under corporate law, and that you record those meetings, right? That's what the minutes are. The minutes are simply documentary evidence of your meetings. And by the way, those meetings today can be done electronically. We don't have to actually get together in a room. They can be done by telephone. We can even do certain things by unanimous consent, right? Which means that we simply pass around a document saying what we want to do, and everybody signs it, and we can do that in lieu of a meeting, right? But you have to make sure that those things are documented. Fail to maintain separate bank accounts and records. That's really important, especially when you have just one person who owns the business. Sometimes people get a little sloppy and they use their personal accounts and their to put business transactions in, or vice versa. And this is true whether you have a sole proprietorship or a corporation or LLC or anything else. You want to make sure you have separate accounts and separate records. You need to treat that business as if it's not you, as if it's something else, for a variety of reasons, for tax reasons, for liability reasons. In the case of a corporation, for the liability that might be attenuate to piercing the corporate veil. You don't want to commingle assets. Again, you don't want business transactions going through your personal accounts and vice versa. Right? You want to make sure that you separate those accounts adequately. Formalities, again, a big deal with corporations, not so much with LLCs. That's one of the advantages with LLCs. There aren't a lot of formalities. Well, the corporations, you do have to have the annual meeting. You do have to elect directors, unless you're a closed corporation, on an annual basis. And then finally, we have undercapitalization. The law doesn't allow you to use a corporation to defraud creditors. And what we mean by undercapitalization is if the corporation doesn't have sufficient assets to conduct business. In other words, if it's just basically a shell and you're just using it to try to obtain liability protection, sometimes the courts will disregard the corporation. They'll say the corporation, is not a real thing because you never capitalized it with enough assets, with enough money to actually operate as a corporation. It was just basically your alter ego. It was just you in the form of a corporate shell, and that is effectively a fraud on your creditors, and therefore will ignore the corporation. So that can happen, right? Now, these are all dangers, and again, they're dangers that can be avoided with proper planning. And again, that's why it's so important to speak to your attorney about these things. And in fact, all along I've been saying speak to your attorney. The reality is all of this should be done as a team effort, right? When you're doing estate and business planning, your team should consist of at least your attorney, of course, and your tax advisor, your CPA. Those people should be working together, because if you don't do that, some of the things that your tax advisor is doing with respect to either positions they're taking on a tax return or any ancillary tax planning they might be doing, it might not correspond to the estate and business planning that your attorney's putting in place. The old days where we used to be able to sort of think of those things separately, those days are gone. Everything is complex now. Everything is interwoven, and something that your CPA is doing is invariably going to affect your business or estate planning that your attorney is doing, and vice versa. All right, so you really need a team approach. Now, you might have, the attorney might be sort of the lead member of the team, or it might be the CPA that's the lead member of the team, and the attorney steps in to draft documents based on the planning that's done primarily led by the CPA. The problem is most of these issues have both legal and tax and sometimes other business consequences, and so you really need all of that input in order to plan properly. So how do you prevent veiled piercing? Well, again, just what I was already saying, right? You got to maintain appropriate books and records, maintain separate bank accounts, make sure you do your corporate minutes, make sure all of your employment arrangements are set up properly, right? You have to have a withholding account. You got to do withholding for your employees. But you can't just treat everybody as an independent contractor necessarily, right? Whether somebody is an employee or independent contractor is determined based on the facts, right? It's not just whatever you decide, right? So without getting into a lot of detail, basically, the more you control the person, right? If you tell them when they have to come to work and what they have to do, generally speaking, that means they're your employee. All right, and that means you have to do withholding for them. You have to pay half of the FICA tax, etc. You can't just decide, even if you agree, even if the worker and you agree that they'll be treated as an independent contractor, the state or the IRS can still come in and say, no, the facts say they're an employee. And so, again, that's an analysis you want to do in conjunction with your lawyer to determine if you have any independent contractors or people you're treating as independent contractors who really need to be treated as employees. Now, you may be able to rearrange the situation, change the facts, in other words, as to how you're interacting with each other to change that result, right? But again, that's something that needs to be done deliberately, needs to be thought through. Otherwise, if you have an employee, you need to make sure that you respect the formalities of employment, including withholding and everything dealing with payroll. One of the issues that people sometimes have that, of course, is certain retirement plans, for example, you're going to have to cover those employees. You don't have to cover independent contractors, which is one of the reasons sometimes people like to they prefer just to treat somebody as an independent contractor. But again, it's really important to understand that you can't just decide to do that. You may be treating somebody as an independent contractor who the IRS or the state might treat as an employee, and then you're stuck with all sorts of back taxes, the taxes that you haven't withheld. And by the way, there's all sorts of ways that can come about. Certainly, if you get audited, that's something that the IRS or the state might look at. Even a disgruntled ex-worker. So if you're treating somebody as an independent contractor and then you have some sort of a dispute with them and they leave, there's actually a form, right, that they can file with the IRS, basically saying, look, this company was treating me as an independent contractor, but I think I was really an employee. And then the IRS is compelled to do an investigation. So it's really important to make sure you have your ducks in a row in that regard. So if you have people working for you that you're treating as independent contractors, you really should have your attorney at least give a brief look at that situation to determine if you have any substantial risk associated with that. Then if you do, that might warrant a more in-depth analysis. But it's something that should always be addressed one way or another. Right? Also, when you're doing things on behalf of the business, make sure the other party knows you're doing it on behalf of the business. So in other words, you shouldn't sign contracts in your own name, right? If you're signing contract if you're signing a contract on behalf of the business, the signature line itself should indicate that. So rather than saying, Joe Smith, rather than signing the document Joe Smith, you sign it XYZ Company by Joe Smith, president or member or whatever the case may be. You want to make sure you're signing documents in a representative capacity so that there's no dispute that you're entering into a transaction by yourself. What happens is you own a corporation and you enter into some transaction which you understand to be between the third party and the corporation, but you signed the agreement just in your own name. It's possible that that third party might later argue that no, their agreement was with you personally, and it's to their benefit to do that typically because that means your personal assets are available for satisfaction of a judgment. So you got to be careful about those things. And again, this is something that your attorney can educate you about, and that your contracts and the way you structure transactions should be reviewed to make sure that you're not doing something at cross purposes with your business plan. Mistake number 6, failing to properly plan for family business succession. Family businesses can be tricky in lots of different ways. First of all, you have to be realistic about who wants to participate. Sometimes people who form a family business, start a family business, they have this dream of their children, coming in and taking over the business upon their retirement or their death. And sometimes it works out that way, but sometimes the children don't want to take over the family business. So you have to be realistic and plan for what the reality is, right? And you can plan options. Maybe your children are young. You don't know if they're going to want to be involved in the business or not. There are options we can use. There's flexibility that we can use to account for that fact. You have to do some sort of evaluation process. And flexibility, as I said, is the key. Now, you might want to form what we sometimes refer to as a family council, where we're not just doing the estate and business planning one-on-one. We're not just getting your input, but we're talking to the whole family about how they, with respect to just the business, right? We don't have to talk to the whole family about your entire estate and business planning process, but with respect to a specific set of family business assets, we might want to have a family council to decide, whose interests are what. Some people might be more interested in parts of the business or other parts of the business. I had a client not long ago who had a very successful business, but a small business, a closely held business, just a husband and wife owned the business. They had 2 children, and the 2 children both wanted to work in the business, both wanted to be involved. In fact, were working in the business. And so, initially the client, the husband and wife, thought, well, they'll just leave the business to the kids, because they both wanted the business. Well, the problem is the kids did not get along, right? And it became apparent early on that if that business was just left to the 2 children so that they each, held half of the business, that business would likely fail almost immediately because those kids could not work together. They could not get along. And so what did we do? Well, we were able to figure out a way that upon the death of the owner, the husband and wife, we could split the business up into two components, right? In this particular case, we're able to identify two sort of parts of the business that could operate independently. And we simply were able to give one component each to the two children so that they didn't have to work together. The business itself could still remain functioning, and those two children could still be owners, but not owners together. All right. Now that's something that if we hadn't considered that, and that client just left the business to the children, as I said, I'm pretty confident that business would have simply, dried up a short period of time after the original owners passed away. Some of the considerations, well, the entity choice is a consideration. Now, we use oftentimes family limited partnerships or FLPs for family businesses. Now, we use FLPs for a variety of reasons, not so much organizationally, although they have some organizational advantages, but we use that as part of the estate and business planning process because with a family limited partnership, we can structure it in a way, if we do it soon enough, right? You can't do this when you're on your deathbed, but if we do it soon enough, we can structure it in a way where you slice off pieces of that business during your lifetime and transfer them to your children tax-free, so that if you plan it properly and if you have a long enough period, you can transfer most of the business to your children during your lifetime without any gift tax. And then you die still controlling the business, but only just a small part of it. So only a small piece of the business goes into your estate. And that way we can avoid estate taxes and have the business already in the hands of the children. And you don't have to give up control to do that. Right? So that's what the concept of a family limited partnership is. Now we call them family limited partnerships because historically that's what we've used, right? We've used partnerships, but we can use LLCs. And in fact, most commonly do use LLCs these days because the LLC is just a little more flexible. But both things can serve the same purpose. You can have a family limited liability company. You can have S corporations. Now, one of the problems with S corporations is you can only have one class of stock in an S corporation. So you can't have preferred stock and common stock. You can't divide up the business through stock ownership in that way. You can have non-voting stock, however. So you can transfer S corporation stock to children, for example, and not give them any voting rights. So they don't have any vote in the corporation, but they still have full economic rights. Again, all of this needs to be integrated between your business plan and your estate plan. The IRS does scrutinize, especially family limited partnerships. They scrutinize them very carefully. The key thing with a family limited partnership is that you really have to be forming a partnership. And the real issue there is that you really have to be transferring assets to the partnership. That's the biggest issue. You can't just pretend to transfer assets, right? You can't say that you're transferring the business to this family limited partnership, but you still retain all the control of business and you still run the business as if it's your own personal business. Now you can still maintain control, but we have to set it up and structure it correctly so that retention of control will be respected by the IRS, or more specifically, the transfer will be respected by the IRS. So some of the things that you want to avoid is you don't want to transfer all your assets to the family limited partnership. Sometimes people look at the family limited partnership and they say, well, if a little of it's good, a lot of it must be better. So we'll transfer everything we own to the family limited partnership. And the problem is the IRS says, well, if you've transferred everything, then you don't have anything to live on. And so that can't possibly be the case. And therefore, we're just going to ignore what you think you've done. We're going to pretend as if you didn't transfer anything. All right. So you got to be careful about how you structure it in that way. You want to make sure it's properly documented. You want to make sure you respect the details. In other words, partners are treated as partners. If you have a partnership meeting, that means you have a partnership meeting with all the partners. And things like that. They said this is something you can't do on your deathbed. You have to do planning for this. If you attempt to do this, once you've been diagnosed with a terminal illness and it's evident that you don't have a lot longer to live, if you start trying to transfer assets at that time, chances are those transfers won't be respected. All right. Mistake number 7, not considering the income tax ramifications of each decision. and not taking advantage of all available tax opportunities. I tell you, one of the biggest frustrations that as a tax lawyer I have, and most CPAs will tell you the same thing, is too often clients come to us after something's been done. Right? The client comes to us and they've bought a business, or they've sold a business, or they've restructured their business somehow, and then they come to us and say, okay, well, what are the tax ramifications? Well, the problem is sometimes those tax ramifications might be negative, and they might also be avoidable if the client had come to us before they entered into the transaction. You know, I have a saying that I repeat to my colleagues and my clients all the time, and that is tax touches everything. And it really does, certainly with respect to business. Any sort of transaction you're going to be involved in is going to have a tax ramification. Now, that doesn't mean that you have to call your tax lawyer every time you have an interaction with a customer. But for those big things, for how you're structuring your employment agreements, and a big transaction with a client perhaps, or the sale or purchase of part of your business, those things you really want to run by your tax advisor, either your attorney or your CPA, before you enter into the transaction. Two things that you should always think about and always keep in mind is that every investment or business decision has some tax implications, and the tax laws will change frequently. Right now, our screen says the tax law will change every year. That's not necessarily the case, but they change often enough. And so, if you're not keeping up, if you're a transaction that might have been perfectly beneficial and have no detrimental tax impacts last year, might be just the opposite this year, right? So you have to make sure that you're in constant contact with your team. And again, I think it should be a team, both your tax advisor and tax preparer and your attorney. C corporations, generally subject to double taxation. What do we mean by that? Well, remember I said earlier, a corporation is a separate person. So just like every other separate person, the corporation pays its own tax. It files its own tax return, pays its own tax. Now, in a small business, in a big business, that's not such a big deal, right? If in Microsoft, the space between when Microsoft earns money and when that money eventually gets paid to the shareholders as a dividend, there's a lot of distance between that. And so the fact that Microsoft has to pay tax, and then the shareholders later pay tax and dividends, that's not such a big deal. In a small business, or a modest-sized business, a closely held business, generally the idea is whatever the business earns goes into your pocket, right? There's sort of a direct impact. Well, in that case, the double taxation with C corporations becomes more evident, because now, although the money might be going directly from the corporation into your pocket, it has to stop at the corporation, and a tax has to be paid on it first. And then, of course, you pay tax on it again when it goes into your pocket. And that's the concept of double taxation. Now, double taxation is not necessarily bad. There are circumstances where double taxation will benefit you. There are certain benefits of a C corporation that may only be accessible through a C corporation, and may be more beneficial to you to pay a double tax. First of all, you don't pay any double tax if you're not pulling any money out of the corporation. You're not paying a double tax if you pull all the money out of the corporation, right? Because if there's no income in the corporation, there's no corporate tax. So I want to caution you against the knee-jerk reaction that C corporations should be avoided, even for small businesses. Sometimes they're exactly what you need. Now, S corporations are corporations, but they're not double taxed. There's a special rule that says if you qualify to be an S corporation and you elect to be an S corporation, then the income that the corporation earns is directly taxed to you. We don't stop at the corporate level to pay a separate tax. Generally, there are circumstances where a separate tax has to be paid. But with an LLC or a partnership, LLCs are the most flexible, right? Partnerships are taxed as flow-through entities all the time. LLCs can be taxed as either partnerships or as corporations. So with an LLC, we have flexibility to decide what the best tax situation is in your particular facts and circumstances. When you buy or sell a business, there's lots of decisions that have to be made. Are we buying the assets of the business or selling the assets of the business, or the ownership interest, the stock, for example? There's lots of different tax ramifications to that. For example, if you're buying a business, Generally, you want to buy assets. The reason for that is it generally gives you favorable depreciation deductions going forward. You can't deduct the cost of the business immediately in most cases, but you can write it off through depreciation. Well, you want to be able to write it off as quickly as possible. Some assets get depreciated more quickly than other assets. When we buy a business, we have to do an allocation of the purchase price, all right? And both parties have to cooperate in that allocation. Intangible items, goodwill, things like that, and oftentimes in a small business, goodwill and customer lists are sometimes the most valuable assets. They're written off over a 15-year period. If there's going to be any consulting compensation, right, the person who receives the consulting compensation recognizes that as income right away. The payer of this consulting compensation may or may not be able to get to deduct it right away, depending on how it's structured. So again, planning is really important in that particular regard. Other tax savings opportunities that cross over between your business and estate planning, of course, are things like funding your retirement accounts, funding your defined contribution accounts like the 401k. Generally speaking, the first thought we have oftentimes in estate planning and in business planning is make sure we're funding those amounts up to the maximum. With a small business, sometimes, and this is a relatively narrow set of circumstances, but sometimes even a defined benefit plan, the old-fashioned pension, might actually be beneficial. Now, generally speaking, that's not the case because defined benefit plans are complicated and they're expensive. But sometimes, if the circumstances are right, the benefits of a defined benefit plan can far outweigh the complications and the costs. So again, that's something you have to discuss with your advisor based on the facts and circumstances. That's usually not going to be the case, but just like with C corporations, it's important not to discount that entirely. Defined benefit plan may be exactly the thing you need. And there's all sorts of factors, of course, right? We have to decide who's involved, who are the beneficiaries, what are their tax rates, what are their financial needs. Again, they should all be integrated, not just addressed in your estate plan, but integrated into your estate and business plan. Mistake number 8, failing to incorporate trusts adequately for asset protection purposes. We talked about asset protection. Trusts are great vehicles for asset protection, not for your own asset protection, all right? There's some difficulty with what we call a self-settled trust, right? And that simply means that you take your own assets and put them into a trust of which you are the beneficiary. Now, the general rule is, well, that doesn't work. The general rule under the law is that if you can get to the assets, so can your creditors. Now, there are these things called domestic asset protection trusts, and we can use them. We don't have them in Maryland, but we can use one from another state. We have them in Delaware, and Nevada, and several other states, right? And we can pick the state law that's most beneficial to you. Now, the problem is with a domestic asset protection trust, you put your assets or some of your assets into this trust and you are the beneficiary of them, but you have to have a separate trustee, and the trustee has to have discretion, which means that you do give up control of those assets. Now, that might be the right thing to do under certain circumstances, right? But that's not the only way trusts can protect assets. Trusts can always protect, be a shield against creditors of the beneficiaries, right? So suppose you have a beneficiary that you want to transfer your assets to upon your death, but they have a lot of creditors. I had a client recently who had a child, a grown man, but an adult child, who they wanted to transfer much of their assets to upon their death. The problem was the child had all sorts of creditors. They had business creditors, they had been through divorces, right? They had all sorts of people that wanted to get their hands on that person's money. Well, if you just give them the assets upon your death, those assets are going to be available to all those creditors. If you put it into trust, you can protect those assets from creditors. Most trusts will have a spendthrift provision. Spendthrift provision just simply says that the beneficiary cannot transfer their interest in the trust. Right? Again, it prevents the beneficiary from being able to use their interest in the trust to pay off creditors. So it protects the assets within the trust. There's also other benefits of a trust, of course, some of which we've already mentioned, to protect disabled beneficiaries, people who just aren't in a position to manage their assets, right? We can manage them through a trust. And so Trusts have all sorts of benefits. We use special trusts for life insurance or for your personal residence. Those trusts are commonly used as tax planning trusts, right? They have the effect, among other things, they have the effect of removing assets from your estate. So trusts have all sorts of benefits. And that brings us to mistake number 9, failing to consider the options available to finance long-term care needs. The fact of the matter is, many of us, most of us, in fact, are probably going to have long-term care needs at some point. We are living longer, and we tend to be, healthier in the sense that we're not chronically ill or terminally ill for a long period of our lives. So that means that you may have to have assistance. You may have to be in a nursing home for a substantial period of time. But that hasn't always been the case, right? Even in my lifetime when I was young, the average life expectancy, well, a good example is with Social Security. The reason that the retirement age originally for Social Security was 65 is because the average life expectancy of an American male in the 1940s, when Social Security went into effect, was 65. People, just didn't live that long after retirement. Those things have changed. It's not at all unusual to live well into your 90s and even live past 100. Well, oftentimes, although we might be healthy in the sense of being able to, enjoy life and interact with people, our bodies do tend to deteriorate. And so, we may not have good needs. We may need respiratory care. There's all sorts of things that may require that we be in a nursing home or other institution for a long period of time. Well, those get expensive. And so we need to think through in our estate planning how we're going to handle that. If you're going to look at long-term care insurance, there's all sorts of features that you have to consider. Of course, how much it's going to cost. The older you are when you buy it, the more expensive it's going to be. How long of a deductible period do you have? What the benefit is? Exclusions, like with any insurance policy, you got to make sure the insurance is adequate. Whether there's an inflation rider, right? If you're buying it when you're young, that might be a good idea, more affordable then, but the cost of nursing home care is probably going to go up. And so you want to make sure you have an inflation rider of some sort. What about a waiver of premium, right? If you get disabled, you don't want to lose insurance you've been paying premiums on for years just because you become disabled for a temporary period of time and don't have the income to pay the premiums. So there's all sorts of features that should be considered and discussed, again, and integrated into your estate planning along with your business planning. And then finally, there's a couple of other alternatives. Life insurance. Life insurance doesn't help you for nursing home care, of course, but it can replace wealth that's lost due to the assets you have to expend on your long-term care. And of course, Medicaid planning. Medicaid is government payment of your long-term care needs, right? Medicaid actually covers all healthcare needs, but we do Medicaid planning typically for long-term care needs. Now, Medicaid is available to those who are impoverished. So Medicaid planning basically involves deliberately impoverishing yourself, right? But doing it in such a way that's beneficial to your family. So we can make transfers of assets, for example, into trusts so that they're not counted as a resource for you when you apply for Medicaid. Now, in order to do that, you generally have to plan in advance. Transfers within 5 years will generally be ignored for this purpose. So you have to do it at least 5 years in advance. You want to be able to protect the spouse, right? Oftentimes, both spouses don't have to go into a nursing home. Maybe just one of them does. Well, what we call the community spouse needs to be protected. So today we've talked about a whole bunch of issues that each of which really requires an integration of your business and estate planning needs. And feel free to contact us anytime and to discuss these things. Or if you already have an estate plan in place or you have some business planning documents in place, we can review those and determine if some adjustment needs to be needed or what we need to do to integrate the two. But it is really essential that whenever there's a significant business involved, significant business assets involved, you really need to integrate your estate planning and your business planning. They're not two separate things. They're really one part of a whole set of circumstances that has to be addressed. So with that, I'm going to end our presentation. If you have any questions, certainly let us know. You can contact me at the firm or through Jeff. I work at the firm. I have an office at the firm. I also have a separate business, as Jeff said, the Borek Group, and my email for the Borek Group is just chuck@borekgroup.com. Please feel free to contact me anytime with any questions about what we've talked about or anything else related to tax or business or estate plan. Thanks very much, and that'll end our webinar.
Well, thank you, Chuck. Really thorough presentation, really well done. I believe gives our attendees a lot to consider, and just had some comments from some attendees, just the way you share information and kind of mold differing ideas kind of into one thought is really appreciated, and just a great presenting skill that you have. So thank you very much for your time and your expertise. Really appreciate it. And it's nice to have you back, and hope to have you back again soon.
Yeah, thanks.
So yeah, our pleasure, and thank you. Do have one question. Please get your questions in. I'm sure you've got questions swimming around in your heads after all that great information. Now is your time to get those questions into me. We do have one question for you, and that question, along with the mention of a great presentation by you, is, do you help with if a client is considering a buyout of their business, or when they decide to sell their business to a new buyer? Is that something that you would personally handle, or is that something that you would work with somebody else in helping to address?
No, I handle those types of transactions. My background is primarily in business and tax. I also do estate planning. The estate planning I typically do in conjunction with the lawyers at Elville, the other lawyers, but I have a estate planning background, but primarily I'm a tax and business lawyer. So yeah, I handle the purchase and sale of businesses.
Okay, very good.
All right.
Here. Any other questions for Chuck? So while you're getting those questions in, if you do have them, oh, wait a minute, have one popping up here. So it says consulting, question mark. Do you mean the business is the, let's see here. It's kind of worded a little bit differently here. So, okay, consulting, question mark. Do you mean the business is the book value of a business? How is the business valued if not book value? Based on income or policies and procedures, or client relationships / list, referral lists?
Yeah, I think what they're getting there is businesses don't have a lot of assets. Book value refers to your assets. So if you're a business, for example, that invests in real estate, book value, if it's all raw land and there's no depreciation, might be a fair reflection of your value. But if you're in a consulting business or a professional service business like a lawyer or a CPA, typically you don't have businesses. We typically value them based on income. And there's a variety of different approaches to valuation based on income. But that's typically how those businesses would be valued.
Okay. Can you repeat your email address, please, Chuck, so I can send it out to the group here?
Sure. Well, I have two, right? You can always contact me at chuck@Borek Group, BOREK Group.com. Or you can contact me at my Elville and Associates email address, which is just chuck@ElvilleAssociates.com. Either way will get to me, and I'll be happy again to address any questions you have, or point you in the right direction if I can assist you.
So Michael, who posed that question, I just sent that in the chat box, which you should see in the bottom right portion of your screen. I'll also send that in my follow-up message that I'll be sending to everybody later this afternoon or first thing tomorrow morning as well. I'll include all of Chuck's contact information as well. So another question we have here. If I'm the only owner of the LLC, if nothing specific is said about it in my trust, who owns it when I die and who can get to the bank account? The bank will not set up a TOD because there could be partners in an LLC, even though I don't have any.
Right. Yeah, if it's not including your trust, any asset would belong to your estate, which would mean that you'd have to open an estate and a personal representative would have to be appointed. And then that personal representative would be the one that would have to transact business with respect to that LLC. So you can transfer the LLC into the trust, by the way. And there's other arrangements that can be made, again, depending on your facts and circumstances.
Thank you. Another question. I have a son with autism who draws, and a person wants him to sell his drawing to him for use in a book. He receives SSDI, and should he have his own business to avoid losing his benefits?
Well, there's a couple of ways to handle that. You could set up a business. You could also, in conjunction perhaps with doing that, have a special needs trust. So there are a variety of different ways. Again, depending on what other facts and circumstances there are lots of different ways you can structure that to avoid any impact of the SSDI benefits.
Okay. All right. If we're waiting for any last questions, I'll just mention again, thank you to Chuck, and briefly just a couple of webinars that might be of interest to you. Tomorrow we have our very popular What Families Need to Know About Planning for a Loved One with Special Needs at 10 o'clock. That's going to be with Miss Olivia Holcomb-Volke, our senior principal and senior estate planning attorney here at the firm. And then next Tuesday we have with our elder law attorney, Lindsay Moss, Medicaid long-term care asset protection planning, again at 10 o'clock next Tuesday. That's a new webinar that we're offering here through our webinar series with the firm. So it looks like we do have one more question. So following up to my last question, as a sole owner of an S Corp, I'm researching how to transfer of stock to key employees upon my death using life insurance as a vehicle to fund the transfer of stock. Is there a way to do this without employees owning stock prior to my death?
Yeah, there's, again, a couple of options you have there. I mean, one option is we can use trust. Now, there's special rules for trusts that hold S corporation stock, but there are a couple of options there. We can also have, we can institute a stock option plan and structure that for the employees so that they have the ability to buy the stock with insurance upon your death. So, with S corporation stock, there are some special considerations over just, regular C corporation stock. But yeah, we certainly, there are different ways to achieve what you're trying to achieve. Yeah.
Okay.
All right.
Last call for questions, and thank you for the questions. They help everybody learn. And keep Chuck on his toes because he doesn't see them. No, nothing stumps Chuck.
Again, as any, when things come up, feel free to contact us. And
yeah, absolutely.
I'm an educator at heart, right? I've been teaching for 30 years, and I love to if I can't answer a question for you, I'll certainly try to point you in the right direction. So
absolutely.
feel free to contact us anytime. Yeah.
So it looks like that's going to end our questions, and just want to thank everybody for being here today. Hope you learned something. I know I did, and want to thank you for your support of our Elville webinar series, and hope to see you again soon. And we'd certainly like to welcome Chuck back again here real soon as well. So thanks everybody. Hope you have a great rest of the day and a great rest of the week. Take care.
Thank you.
Thank you.